Hannah Mackey on behalf of Mrs. Mopkin, who is approaching.
No, look this way, ma'am. Come on up. Your name?
Patricia Mopkin.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. And all discovery is complete as far as we are aware.
Would the people have their witnesses available the 20th? Preliminary examination in person will be set January 20th, 2026, 9 a.m. before Judge.
This case escalates fast. A working mother, 4 children depending on her, now standing in a courtroom facing accusations involving a hammer, a knife, and life-altering consequences. The defense paints desperation and self-defense. The prosecution paints extreme violence. And right here, before bond is even decided, you can already feel the tension building. The question is simple but explosive. Is this a tragic act of survival or a dangerous individual who should not walk free? Stay with us because this hearing takes a turn no one in that courtroom expects.
Fresh hour.
May I address bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them, Ms. Latricia is the sole provider for her kids' kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Ms. Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Response.
Your Honor, at this point, I'm going to object. This is an extremely serious case in which the victim was attacked with a hammer in which she was hit in the head several times with that hammer. There was a struggle then for that hammer, and during that struggle, he was then stabbed in his stomach. So given the severity of this case and the injuries that she sustained, I'm going to object at this point.
This is a critical moment. Bond hearings aren't about guilt or innocence, they're about risk. The judge is weighing public safety, the seriousness of the alleged offense, and whether conditions like GPS tethering would be enough. Notice how the prosecutor emphasizes the sequence: blunt force trauma first, then a stabbing. That matters. Self-defense claims weaken quickly when the alleged victim is unarmed. So here's the real legal tension. Does hardship outweigh public safety, or does the nature of the injuries shut the door completely? What would you have ruled at this point?
Your Honor, we are presenting this case as a self-defense, and Ms. Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. Are you saying that a weapon was possessed? Because
No.
that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Do this. There's the allegation that there are 2 weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that even, well, I'll factor that in. I still don't think bond would be appropriate, or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before Judge Freshow.
Thank you, Your Honor.
Thank you.
This is an answer on the other one.
Looks good. Guys wanna walk around? Young lady? No, come here. Come here. Oh, boy. Get her, Mr. Allen. Who is that? Who was it?
Family of the last client, I believe, Your Honor.
To the full moon.
What?
To the full moon.
No, people are usually better. They're not back yet. There's a problem. You got a problem probably in the hallway, guys. I'm sure security sees it. Can you just call and make sure that they're
So, plus the custody. 2.
And you got that over there.
Should have given bond. Yes, I'm so sorry. Yes, so matter has come. I looked up in JIS yesterday, see the company's office called. They don't know. It's on next week. So.
right. I'm gonna just step off. If she brings them in, just throw her in the box over here or cuff her, put her wherever. Hey, lady, what's your name?
Sequoia Jones.
What?
Sequoia Jones.
Why were you causing a disruption in the court and then
I
didn't
was
come
talking to
back?
my mom's lawyer and he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
I apologize.
That doesn't work that way.
Your Honor,
You want to be represented by counsel, ma'am, because you disrupted these entire proceedings. You want an attorney?
Yeah.
The PD can handle this, I think. She can go back into custody. I'm going to take a brief.
This is where courtroom decorum becomes the case within the case. The judge isn't reacting emotionally, he's enforcing authority. When someone ignores direct commands, even out of distress, it triggers consequences fast. Judges have wide discretion to hold individuals in contempt to maintain control and fairness for everyone involved. What makes this moment powerful is the human element. A daughter overwhelmed by seeing her mother clashing with a system that doesn't pause for emotions. Should compassion bend courtroom rules, or does order have to come first?
Recess and then I'll bring her back out. We'll deal with it.
All right.
Morning, I'm Mike Getty, Assistant Public Defender on behalf of the respondent, defendant. I don't.
Yeah, yes, she would be responding. Your name, ma'am?
Sequoia Jones.
Ma'am, you know why I held you?
Yes.
Tell me what your thought is on why I did.
Because I disrupted your courtroom.
Yeah, you disrupted the courtroom. And then when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was too much. This is my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really like hear anything else. I was too upset. I'm not using that as an excuse. I take accountability. I was wrong for that. But
Your mom's coming back in a week or two, right?
That's correct, Your Honor.
Huh?
That's correct, Your Honor.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries, and nothing was mentioned about that.
Okay.
And that's what I was
Can
asking
I
her.
just say that?
Oh, okay.
You need to let the attorneys do their job. Okay?
Mhm.
You have an issue to the extent that they'll even talk to you. If you have an issue with them, then you deal with that outside of this courtroom.
This hearing reveals just how layered the justice system can be. On one side, a defendant facing serious violent allegations and denied bond due to the severity of the claims. On the other, a family emotionally unraveling under pressure, reminded that courtrooms demand control, not chaos. The judge's rulings here weren't about sympathy. They were about structure, safety, and accountability. If you found this case as intense and eye-opening as we did, hit that like button, share your thoughts below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
So should I banish you from coming into this courtroom again?
No.
You think you can conduct yourself?
Yeah. Yes.
Young lady, I'm going to give you another chance. If you come back in here and act the way you did, I'm going to guarantee you this. You'll be locked up like you are now, but I'm not letting you out. Are we clear?
Yeah. I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't
Oh,
raised
you
that way.
were today.
I was today, but I'm not.
Not only
every
to
day.
whoever you were talking to, but also to me, and I hadn't done anything to you. Right?
Mhm.
So just check yourself next time before you come in here. All right, we can release you. Let her go.
Thank you.
Thank you. Court is standing in recess, and I guess we'll come back and do our 2 o'clock block and